My name's Stephanie Harrison, Casey. I'm welcoming you to a joint event, which is the launch of a really important report looking at the experiences of accessing education in asylum accommodation. So today we're going to have speakers from both Public Law Project and also from the organisation Together with Migrant Children, who have been central to this project, which has been a joint project with those two organisations and Garden Court in particular, work of my colleague Ollie Percy in contributing to this project. So my role is simply to be the chair. So that means that at the beginning I've just got some practicalities to discuss with you. First of all, just in terms of the slides that you're going to see from the speakers and any recording that is going to be available to you. We are obviously a hybrid event, so we want to, at the end, have questions. We want you to contribute and to raise whatever issues you want about this. And this is ultimately about what steps can be taken to challenge what you're going to hear about a concerning situation. So we definitely want you to participate, whether you're in the room or online. For those people who are online, the easiest way to do that will be to put your questions as you go along in the Q&A, and then we can pick them up at the end. Obviously, if there's anyone who wants to ask any questions later online, then they're able to do so. And obviously, for those who are in the room, we'll take questions at the end. I do have to give you a fire safety announcement. Just in case. I'm sure that we won't have to put this into practice, but if the fire bell did ring, what you have to do is to walk down the main staircase. There are exit signs, and then you walk to the assembly point, which is actually across the road in Lincoln's Inn Fields, and you'll be able to see it will be signposted if we were in that situation. Doors will automatically release if the fire bell rings. So that's covered, I promise. Yeah, as well as having a discussion at the end, there will be an opportunity after the formal event to discuss further. There's some food and drink downstairs, and I hope that we'll carry on discussing what you hear. So what will we be covering? As I said, today is the launch of the report, Experiences of Accessing Education in Asylum Accommodation. And again, the electronic version of that report will be sent to everybody. We will have some hard copy versions of it downstairs at the end. This project was a joint project between Together with Migrant Children, Public Law Project, Garden Court Chambers, and it followed a 6-month research project funded by the Immigration Law Practitioners, that's ILPA's Strategic Legal Fund. So it was obviously an issue that was people were picking up on as being a real problem for children who were in asylum accommodation. And this report addresses both the experiences of organisations who advocate for asylum-seeking children. Obviously, we're going to hear from both Matthew Court and Dr. Jo Hynes of the PLP about the report and the legal context, as well as the methodology for the report and its findings, as well as drawing on, which is obviously critically important, the experience of the children, and in particular the impact of the disadvantages and delays in starting school that they experience as a result of being in asylum accommodation. Obviously, that doesn't only impact on their educational attainment, but also on their general welfare and development. And we're going to hear from both Nick Watts of Together with Migrant Children and Lucy Ricks, that will give us more of an insight into what those experiences mean for the children who are subject to this form of inadequate accommodation for prolonged periods of time. The report also does look at the trends of delay and the school places and their availability for those who are accommodated in NAS accommodation. So what we're going to be able to give you at the end of today, I hope, will be a thorough overview of the key findings of the report, the legal issues that it raises, and be a forum for us to discuss next steps for achieving what this report demonstrates is vital systemic change if we're going to do what the Education Secretary does say in a very convincing and compelling way. Every child, whoever they are, is going to, as her priority, to ensure that they all have access and equal access to a good quality education. That's what she was saying. I listened to Koonsberg yesterday, and she was saying it loud and clear. And let's hope that this report will show that everybody must include asylum-seeking children there is no discrimination in terms of access to this particular form of welfare provision or public service education. It's irrelevant what your immigration status is, so we need to hold the Education Secretary to account when she says every child. Every child must include asylum-seeking children. And so in that context, then it's helpful to start, first of all, by looking at the outline of the legal issues that underpin the research and the legal context in which this issue needs to be fixed. Matthew Court from the Public Law Project is online, so we'll go to him, I hope, seamlessly, and you'll hear from Matthew about the legal context.
Hi, everybody. There I am. I can see myself. Brilliant.
Thank you, Matthew.
Okay, I'm going to share my screen, or at least attempt to, so you can see my slides. Okay, so thank you first of all to Garden Court Chambers for hosting this this event. Apologies I can't be with you in person, but as Stephanie mentioned, I'm going to talk briefly about the legal framework and some of the legal issues and some of the ideas that we've had around potential avenues for challenge to address this issue, before other speakers kind of move on to the more sort of human side of it and the real impact that these decisions or these policies is having on children. So I want to start just by talking very briefly about the duties, or the education related duties, on local authorities. Now, I mention these not because we were necessarily thinking about legal action against local authorities to tackle this issue, although it is an option for individuals, because there are duties on the local authorities in respect of education. I sort of give it more in terms of like giving some context, but also because the Home Office practice, the Home Office policy of moving sometimes large numbers of compulsory school-age children into local authority areas without any consideration of whether there's available school places or not, can frustrate a local authority's ability to comply with these legal duties. And one idea that we had, and it's happened before in sort of different kind of contexts, is that local authorities could, in theory, be claimants to bring judicial review challenges against this Home Office practice. And I'll talk a little bit more about that later. But just for kind of context, these local authority duties. So Section 19 of the Education Act 1996, which I'm sure many people in the room and online will be familiar with, is the duty to make arrangements of education for compulsory school-age children who can't access it without the local authority making such arrangements. And there might be a variety of reasons why children might need the local authority, support the local authority to make arrangements to access education. So some of them are mentioned in Section 19 specifically, like illness, exclusion, but more often than not, children of newly arrived asylum-seeking families are going to need local authority support, arrangements in place to help them to access education because they're new to the country. The system is unfamiliar to them, and so they need that local authority support more often than not to access school or other education. When it talks about education under Section 19, that can be education in school or otherwise in school, providing it's suitable. So some type of remote provision is put in place. It doesn't have to be in school, but it has to be suitable for that individual child. And Section 436A of the Education Act is the duty to have arrangements in place for the local authority to identify children not receiving suitable education. And suitable means efficient full-time education, which is suitable to the child's age, ability, and aptitude, and to any special educational needs that they might have. So moving on next to the powers and duties on the Home Office in respect of accommodation. So this is all found, as you're sure you're familiar with, under the Immigration and Asylum Act 1996. So Section 95 is the power that the Home Office has to provide accommodation and support to asylum seekers and their children who are destitute or likely to become destitute within a prescribed period. Section 96 provides for the types of support which can be provided. So that can be accommodation, it could be cash, it could be both, subsistence. But whatever support is in place must appear to the Secretary of State to be adequate for the needs of the supported person. So it's quite a low bar, adequacy, but that's the kind of bar that there is a bar at least that has to be kind of met. Section 97 provides that when the Home Office is providing accommodation, it must have regard to the desirability to provide accommodation in areas in which there is a ready supply. So that usually means not in London, other parts of the country where there's more accommodation. And that tends to be kind of an overarching kind of consideration for the Home Office, which often trumps other considerations. It's where is there essentially cheap and available accommodation that we can place people. And then Section 98 provides for the provision of temporary accommodation whilst the Secretary of State decides whether a person is eligible for Section 95 accommodation. So basically assessing whether they're destitute. And the way that it normally works is that initial accommodation is provided in Section 98, and then after a certain period of time, the family will be dispersed into what's often termed dispersal accommodation to Section 95. And the effect of this support regime under Section 95, Section 97, Section 98 is that people seeking asylum are often, if not always, accommodated for relatively short periods of time in Section 98 accommodation in one part of the country before being dispersed to Section 95 accommodation in a different part of the country. And it's not uncommon for people to be moved to different types of accommodation located in different parts of the country throughout the life of their asylum claim. So moving on now to the allocation of asylum accommodation policy, which I've referred to there as the AAA policy. So as you probably know, this policy advises Home Office caseworkers on how to consider requests from people who are receiving asylum support and express particular needs or preferences as to where they want to be accommodated. In respect of requests to be accommodated in a particular area because of a child's educational needs, the policy says that these requests should normally be refused. And this is the crucial part, I think, because they say arrangements can be made to transfer the child to a school in another area. So that just assumes the school places across the country. We don't need to kind of, have a place you in one particular area because of your school needs. You can go anywhere in the UK and there'll be a school place for you. That's kind of the premise of it, basically. There's a few concessions to this policy. So one I call the final year exam concession, which says that accommodation in a particular area can temporarily be provided if the child has started their final school or college year leading up to exams, so GCSEs, A-levels or equivalent, provided they've been enrolled in the school for a significant part of the previous school year. But importantly, that concession is somewhat tempered by the policy, which says that individuals will not benefit from this concession if they've previously been uncooperative. So, for example, if they've been offered accommodation and they've turned it down, or they're requesting accommodation for the first time, having received just subsistence support, and have delayed a request for accommodation without good reason in order to take advantage of the concession. And then there's a second concession, which we refer to the special educational needs concession, which says that accommodation in a particular area can be provided if a child with special educational needs has gained entry into an appropriate school. So assuming a school that's meeting those special educational needs. Unless, it says in the policy, it's clear that accommodation can be arranged near another appropriate school that the child can be referred to. And it seems to me that this part of the policy should be replicated across the whole of the policy in respect of education. This idea, which is great, which I think we support, that if you've got a child with special educational needs, you won't move them to another part of the country unless the Home Office is clear there's another school that can accommodate that young person's and that child's needs. And there's no reason that I can see why you can't have that similar kind of thought process going into all education related requests to be in a certain part of the country. The Home Office should kind of think about, well, we're only going to move you to another part of the country if we're clear and it's obvious that there are other school places available for you that you can go to once you have been moved. And that, as the report will find, just doesn't happen. So the issue that's going to you'll hear about from the report from the other speakers is that the asylum support regime can be incredibly disruptive to children's education because there's often frequent moves disrupting existing educational placements. So someone might already be in school and then be moved and have to be taken out of school and then find another school, which can take time. Children and families are often placed into areas where there's a lack of school places. So again, huge delays getting into school. And the unsuitability of asylum support accommodation for effective remote education. Question whether remote education is ever really effective and hardly a comparison to going to school. But Asylum support accommodation often makes it even harder to access remote accommodation, remote education. So particularly with the use of hotels, Wi-Fi connections can be poor. There's little space for children to study and do homework. Often rooms are overcrowded, and so it's very unsuitable. And obviously this is all borne out in the report, which you'll hear more about shortly. So just turning now to some of the potential legal challenges that we've been thinking about, and this kind of report could be used to serve as a vehicle to kind of kickstart some of these challenges, hopefully, or add evidence base to these challenges. So one potential challenge could be to the AAA policy itself in respect of what it says about education. And so what it says, as you remember, is that requests for accommodation in particular areas are often turned down because there's what the policy says, there's school places across the country. This is, as we know, not correct. So in terms of policy challenges, the case of A versus the Secretary of State and Home Department set the standards to be applied by the courts when called upon to review the context of policy documents. So the court said there were 3 types of cases where a policy might be found to be unlawful by reason of what it is said or what it omits to say about the law when giving guidance. So firstly, policy that provides a positive statement of the law which is incorrect. Secondly, where there's a duty on the public authority to issue a policy, it does so, but provides inaccurate advice due to a misstatement or omission about the law. Or thirdly, where there's no duty on the public authority to issue a policy, but it does so anyway, and presents a misleading picture of the true legal position. And so it could be argued that the AAA policy regarding education falls into one of those categories, and that it contains inaccurate information which misleads caseworkers into the assumption that there are sufficient school places across the whole of the UK, when in fact that isn't the case. Some authorities have school places available, others don't, but the policy doesn't reflect that at all. And then finally, other potential legal challenges that could be brought are by individuals challenging individual dispersal decisions. So an individual could challenge a pre-dispersal decision. So they know they're going to be moved to a local, another area, and they've got concerns about the educational impact on their children. They could challenge that on the grounds that there's a failure of the Home Office to investigate the availability of school places prior to dispersal. And so the caseworkers or the Home Office, when assessing adequacy or suitability of accommodation, should ask themselves the right question and take reasonable steps to acquaint themselves with the relevant information to enable them to answer the question, is the proposed accommodation adequate? That's the Tameside duty. There could also be arguments around the Section 55 breach. So that's the duty that requires the Home Office or Secretary of State to have, when discharging immigration functions, to have regard to the need to safeguard and promote the welfare of children. So that could kick in as well and be a relevant ground of challenge. The issue with these kind of challenges, of course, is they have to be brought on an urgent basis. People don't get very much notice when they're going to be dispersed to other accommodation. And once they've moved, the focus then might shift to challenges or correspondence or putting pressure on the local authorities to secure education, rather than focusing still on the Home Office or the Secretary of State. And then finally, nearly finally, an individual could challenge post-dispersal decisions. So challenges to the adequacy of accommodation once they've moved. So the location is not right, there's no schools in the area, hotel accommodation is really poor for remote education. So these are kind of post-dispersal decisions, but again, question whether the right focus at that point might want to be the local authority rather than the Secretary of State. And then finally, just kind of looping back to what I spoke to before, which is in relation to local authorities potentially being claimants to bring challenges against the Home Office policy of moving or placing sometimes large numbers of compulsory school-age children in local authority areas without any consideration of their educational needs or availability of school places. And that's kind of similar to a challenge that was brought recently by Brighton and Hove in relation to the Home Office's practice of accommodating newly arrived unaccompanied asylum-seeking children in hotels. And what Brighton argued was that at the very least it was unlawful for the Home Office to do so without taking into account the additional burden which these children were placed on local authorities in whose area the hotel is situated. So you can see some kind of parallels with that to this kind of issue as well. So I'm going to leave it there. I think I'm on time. I'm going to hand over now to our next speaker. Thank you for your time.
Jo, are you okay to stop sharing? Yes, we lost you for a second there. Yes, I will share my screen. I'm going to assume that's a yes. Everyone else is on mute. Great. Well, thanks so much, everyone, for coming, and thanks for the introduction, Stephanie, and for setting out the legal framework for this piece of work of you. I'm Jo Hynes. I'm a researcher at Public Law Project, and I worked on the data collection for this with Lucy and Nick Together with Migrant Children. So I think Lucy and Nick will speak more to the case studies and some of the findings, but I'm going to outline our method and the survey findings. It's very graph heavy, but all of the graphs are in the report if you want to look afterwards, and I can promise the presentations after mine will be less dry and less graph focused. But just to sort of outline how we went about this project and the kind of sort of key headline findings. The aim of our research was to understand the scale of education delays being experienced by asylum-seeking children. So as Matthew said, we knew sort of anecdotally that there were quite a few examples of asylum-seeking children, often in Section 95 asylum support accommodation with their parents, are then being dispersed to areas and then left in this limbo without a school place. So we wanted to understand the scale of this issue through speaking to support organisations. So in August last year, we circulated a survey to organisations working with asylum-seeking families living in asylum support accommodation. And we got 49 responses to the survey. These were primarily from locally based organisations covering a specific town or area, as well as 15 responses from organisations covering regional, national or international areas. And as you can see from the graph on the right here, the vast majority of our responding organisations were experiencing issues with their clients in asylum support accommodation starting school. And most of these organisations didn't specifically collect or casework data about children receiving asylum support necessarily, but they did have more sort of general data and experiences to draw on to respond to this survey. And we're really grateful for all 49 of them for doing so, because it was quite a long survey. So very thankful for all those responses. So as you can see here, of the 19 organisations who were able to put figures to their response to this question and who had answered yes to experiencing delays overall, all of them had experience of delays of over 4 weeks in children accessing either or both primary or secondary school places. That's the graph on the left. And for smaller organisations, this was sometimes as high as 100% of the total number of asylum-seeking school-aged children that they were supporting. And for some bigger organisations, it was around sort of 20% of the total number of asylum-seeking school-aged children that they supported. So not everyone responded to this question, and 16 responded but couldn't give exact figures. But of these 16, 8 organisations said that they'd experienced delays of over 4 weeks in children accessing either primary or secondary school places. And almost half of the whole 49 organisations who responded reported that they'd supported children who waited for 8 weeks or more for a school place. And these delays, organisations were seeing these delays in accessing school places for children in all types of asylum accommodation, so both initial and contingency accommodation such as hotels, and then dispersal accommodation later too. So in terms of waiting time lengths, 26 organisations responded to say children experienced delays in initial accommodation, this first graph, and 20 responded to say children experienced delays in dispersal accommodation. And they indicated that children they supported were waiting for generally between 3 and 8 weeks for both primary and secondary school places. And in response to the question, what is the longest period a child waited for a school place, 3 organisations said they'd supported children who had waited for over a year to access education. So as well as this kind of really troubling, lengthy delays, we also asked organisations about alternative education provision. I know Matthew mentioned the sort of our concerns around accommodation being an appropriate site for this. But of the 33 organisations who responded to a question about this, 26 said that none of the children they worked with were offered alternative education whilst waiting for a school place. And actually only a few organisations indicated that they'd seen children being offered alternative education either whilst waiting for a school place or instead of a school place. So one organisation is seeing children receiving alternative education provision instead of primary school education, and 6 organisations had seen children receiving this alternative provision instead of secondary school education. And where this was offered, organisations reported that it was mostly children with special educational needs who received this alternative provision. And this, the alternative provision took a range of forms. It was from families being encouraged to attend a family and children's centre, to an 8-week intervention delivered by an ethnic minority and traveller achievement service teacher, or a virtual school setting within a local secondary academy. And 3 organisations additionally responded that they'd either through them or through another charity provided this alternative provision themselves, in the form of ESOL-based provision or similar alternative education run by local charities. Just lastly, respondents told us that they were seeing the full range of issues that we described in the survey, plus some additional ones that 13 organisations went on to outline. So delays in applying for a school place, such as not understanding the application process, lack of support completing school applications, and also delays due to no places at local secondary schools. These 2 were the most common options that were cropping up, but all were highly prevalent, as you can see from this bar chart. So many responses were particularly concerned about financial barriers, including those presented by transport costs. And many respondents said that families they worked with difficulties with the complexity of the application process, often there being several different types of application process and having to do different streams for different schools within the same area. Also language barriers, IT literacy, and a lack of support to complete this process. So experiences of multi-agency arrangements between the Home Office, local authorities and local organisations, and the extent to which they existed or helped also really varied. 2 organisations had experience of formalised multi-agency arrangements with regular meetings, and then an additional 9 had experience of informal arrangements based on their positive relationships with local partners. So I think the last thing I think could be helpful to share at this point is the complexities that exist around children accessing places when they're in years 10 and 11. It's potentially a whole separate issue, and we haven't particularly touched on it here, but organisations did tell us that it was particularly difficult for schools to offer school places to this age group. And so they often ended up in college, which is not always appropriate, or stuck in limbo, experiencing long delays. I think that's it from me on the survey itself, but I'll stick around for questions.
Jo. So we've obviously had the legal framework and the outline of the researchers' findings. What we're now going to move on to with our next speaker, which is Nick Watts from Together with Migrant Children, is the reality of those experiences and some scene setting really for what this means in terms of the lived experience of children in asylum accommodation.
Excellent. Hello. My ground rules are there are no slides. I'm not a lawyer, but I am really good at kids. So we're going to start there and talk a little more about that. Just to briefly introduce Together with Migrant Children, so we're a tiny little diddly charity that so many people, despite us being around for a long time, haven't heard of. We provide quite specialist and intensive casework to children, young people and their families across pretty much everything. So we do a bit of age disputes, a bit of unaccompanied minor care leaver entitlements. We do family projects. So Lucy primarily works on Section 17 work and children with human rights claims to remain in the UK and that side of things. We run a small access to justice project that helps connect families with the very limited number of immigration lawyers that exist, and generally end up supporting families for a very, very long time. So our case loading kind of thing has gone up from about 12 months to about 18, 19 months, that families will have a one-on-one caseworker that they can access all the way through to kind of the end of their journey, getting leave to remain and everything else, which means we get to know our kids quite well. At the park, at a climbing wall that one time, losing one in the zoo, that was my worst thing in 2018, but we do get to know the voices and experiences of the children we kind of work with. With this kind of report, Lucy knows much more about it than I do, so I kind of wanted to set what it means in a slightly more academic children's sense. So I've been doing safeguarding for 17 years now. I've done that in different places and different forms, child protection work for the last 8 years, then specialising in migration. And there's kind of one thing that we all know, and that is children are generally safest in education. That's come out in case review after case review. So taking it out of migration, looking at child deaths over COVID, for example. A lot of those children who experienced really significant harm and abuse had a lack of support, a lack of access to professionals, a lack of access to their kind of education provision, their world being turned upside down and being placed in unsuitable situations. And really, when we think about asylum seeking children in hotel accommodation, we all know that for different reasons, that's not appropriate, it's not safe, and it's not adequate for children. So as well as being about education, this is also about safety and about kind of ensuring kind of welfare paramountcy for children. We also know that education is a really significant protective factor in itself. So simply for a child who comes to the UK, maybe doesn't speak much English, is new here, school is a really vital part of integration into the UK. It's how we make friends, it's how we build our social networks, it's how we carve our identity in our new country and find that semblance of kind of belonging in communities that children are with. Going back to that idea of serious case reviews, there's been a number of asylum-seeking children that have died over years. I think a recent study that I looked at a while back, there are tens and tens of case studies in the last 15 years that look at death of asylum-seeking children. And instead of rewriting the wheel, I have a report from the NSPCC in front of me that did this research, looking at all these case reviews and looking at kind of the experiences of first-generation asylum-seeking children in the UK. And shock horror, this will not surprise you, what they found is that the biggest risk factors for those children are social and cultural isolation due to a lack of network and friends, language barriers, lack of access to services, lack of knowledge about what services are available, and lack of kind of knowledge in how our systems work to be able to access them. And so with those in mind, is there any surprise that we see delays? And I would say that having been to many asylum hotels, including that one we got locked in and the police called on us that one time, that was stressful. We see very different practice. So I live in like leafy Oxfordshire nowadays. And in the town I live in, the local hotel that houses families meets every fortnight with the manager, the representative from Clear Springs, all the charities that work in the town, and we get together, have a good chin wag. The hotel refers families to us, and it's kind of unheard of. And then we get locked in others. So it's kind of a massively kind of variant thing. To that some hotels you will find really help families to access these services, and others very much just kind of leave them in a room to kind of stew a little bit, really. And that alone is kind of a really good reason why we might experience delays, thinking about there's no consistency in the support provided. One town can look very different to another. These hotels are very kind of spread apart. And also we know they're put into lower income neighbourhoods where generally school places are generally more oversubscribed, and then there is a kind of parity of school places. The council where I live dealt with it by literally putting a new classroom on a primary school to make sure those children have school places, and they did that within weeks of that hotel opening, despite being given only a few hours notice of it opening. So it can be done, is the key thing. There is, if there's will and there's a bit of money and there's some kind of ways to do it, it can be done. But I think we find there's a lot of kind of variation in how and why that's kind of done. In terms of kind of what the report kind of means, it's kind of horrific to see that so many people are literally struggling to get what is a fundamental human right for children. And as Lucy will do so much better than me in a minute, we got stuff from children as part of this report, from parents, from people who work with children. And this has a huge kind of human impact on kids. It doesn't matter if it's 4 weeks, it doesn't matter if it's 8 weeks, it doesn't matter if it's a year. Most kids, regardless of their background, want to find friends and do their thing and be mobile, build their social capital, go on and live life and run around and kick a ball. That's what most kids want to do. And by taking away education from children, we're almost removing that opportunity to development to social integration to building those networks and helping children to kind of have a successful start in the UK after what has been usually considerable amounts of trauma, adverse childhood experiences, and risks that kind of really have a potential to seriously harm their development, their safety, and their kind of well-being in the long run. We know from research from 50 years of early help research, we know that the earlier people intervene in children's lives, generally the better the outcome, be that education and whatnot. You start looking at safeguarding research, and the research tells us that that intervention is best when it is light touch and the minimum possible necessary to meet that family's need, build their capital underneath it. Rule number one of family support: find what's going well in a family, do more of that. That's kind of safeguarding in a 30-second nutshell. And by taking away that one core universal service for children, we are preventing all of that from happening. So it's really, really important that asylum-seeking children, and any child for that matter, has access to high quality, decent education that is tailored to their needs sooner, and not 8, 10, 1 year, however far down the line. I think on that note, I will hand over to dearest Lucy to talk about lots and lots of experiences.
I have one slide. Thank you very much for everyone for joining us tonight, and to Steph and to the previous speakers and everyone who took the time to contribute to the survey and the research work, and particularly to the families who agreed to allow us to publish their experiences as case studies in the report. As Nick said, I'm a family support worker at Together with Migrant Children, so sadly I'm very familiar with the issue of delay to schooling experienced by families seeking sanctuary in the UK. I think it's unlikely that anyone here tonight, or indeed anyone working in the migration field, will be at all surprised by the findings of this research, or by the impact that being out of school for long periods has on children, and also being moved between several different schools also has a knock-on impact on schools and teachers and other pupils. We were really hoping that we'd have someone here today who could speak about their own experience of education delay, but for several reasons this wasn't possible. However, we did get consent to read out some testimony, which was given to us by a 13-year-old who's experienced being out of school for several months as a result of no school place while she was in asylum accommodation. Others have covered the legal situation and the findings of the research, so I'm going to summarise some of the issues raised in the case studies. I think we're all fairly clear on what it means, and Nick's touched on this too, for any child to be out of school, and particularly a child who may have experienced high levels of trauma, left their home country, friends, family, and is likely to be in very poor quality, often hotel or hostel accommodation, who may have experienced previously a highly disrupted education and may speak little English. What I think is quite striking about the case studies, and Nick also touched on this actually, is how they evidence the total lottery that asylum-seeking children and parents face when they're applying for school places. It seems that the Home Office generally expects hotel staff to support parents to make the application, and sometimes this seems to work, however, like in Nick's case. However, on many occasions, it's clear that several weeks later, applications were never made or never followed up. It's completely hit and miss. Some families have a higher level of English or friends that might be able to support them, others do not. In one hotel, I realised that an 11-year-old Kurdish girl who had fairly fluent English, was actually sharing a lot of information with other families on how to apply for school places, and then interpreting for them with hotel staff, quite successfully, actually. But families are generally given no clarity about the process, the time frame, their rights, what to do if their children are not provided with school places within a certain period of time. So this information often gets gleaned from other families with inevitably quite mixed results. In addition, it's clear just how complex, and other people have touched on this, it is to apply for schools. And I think any parent in the UK will know that that's true. And this was raised in many of the case studies and by many of the organisations who answered the survey. Some families actually try just walking into their nearest school and trying to ask for places for their children. And again, this is actually quite hit and miss. Sometimes staff in the school would assist them to make an application. Sometimes they're just told you have to contact the council. And occasionally, if the school had a place in the right year group that they wanted to be filled, they might actually contact the council themselves and ask for the place to be allocated. However, when another family tried exactly the same approach, they were likely to be turned away, resulting in lots of confusion and frustration. As many advocates pointed out in the research, there's also a dizzying array of types of schools. Supplementary forms that have to be filled in, issues if you're near a borough boundary or an area boundary, or you wish to apply for a particular type of school, a faith school or a non-faith school, let alone all the Ofsted reports, additional SEN support, which has been touched on, support for pupils with English as an additional language or having experienced trauma. These become factors that most asylum-seeking families are just not able to consider when they're applying for schools. Then there is the issue of poverty, which has also been touched on, and how this impacts on being able to access the school place that may have been allocated. How is it going to be possible to pay for the bus or buses to accompany your child to school, a new school uniform? What happens when the school tells you your children aren't eligible for free school meals, when in fact they are, but the system is so complicated that the school has to apply an entirely different process? As it's clear from the case studies, particularly in one case study that was provided by a family at Caras, even if a family does have access to an advocacy service, it remains almost impossible to access any additional payments to cover these kind of costs without access to a lawyer. So I've never seen a Section 96 payment, for example, accessed without legal support. But why on earth should the family require legal support just in order to be able to pay for a bus so their child can attend school? The state has made parents legally obligated to ensure that their children attend school, and then they can face fines and penalties if their children are absent. And yet here is the state effectively preventing parents from getting their children to school. And then when the precious place is finally obtained, the school uniform is perhaps provided by the school or donated second-hand, school meals are finally accessed, the child has been through perhaps another delay by being not able to afford the bus, they've just started to make a few friends and feel a little safer, and then what? The Home Office moves them, sometimes with 24 hours notice, to a new location, and they have to begin the entire process again, or perhaps make a very difficult choice to traipse their child on a very lengthy journey, sometimes up to something like 2 hours each way, just in order to get back to their old school, because the parent so desperately wants to maintain some sense of stability for their children and not have them out of school for yet another period of delay. Some of the survey respondents described requests, and we touched on this in the findings, made to the Home Office for a family to remain in the same area so their children didn't have to move schools. But they're nearly always refused unless the child is sitting public exams, as was touched on. But even this can be a struggle, and families may well not be informed that they have that right. We also need to bear in mind that the case studies in the report are from families who manage to access advocacy or even a lawyer to support them in getting their child into school. The vast majority of families don't have access to such support, and therefore the periods of delay that their children might experience out of school might be longer. I hope that lawyers can successfully challenge the Home Office allocation of accommodation policy with regards to education for asylum-seeking children, in order to ensure that school places are available where families are being accommodated, and that schools can be informed of children arriving in advance of moves being made, so that periods of delay are substantially reduced. However, it's also clear from the issues raised in the research that some of the more fundamental problems that are being faced by asylum-seeking children and their families, such as state-sanctioned destitution, long periods in unsuitable accommodation, such as hotels, high levels of mobility without consultation, delays to the asylum system, lack of access to clear and accessible information and support while navigating complex UK systems are also required. The delay to education suffered by asylum-seeking children is a brick in the wall of the hostile environment that continues to prevent families from connecting and building communities, finding stability and a sense of belonging. As I mentioned, although we weren't able to facilitate someone with lived experience from speaking tonight, I want to read an extract from a statement with consent provided by a child who's now 13, who arrived in the UK with her mum in 2019. Her family sought asylum in 2020, and they were in asylum accommodation for around 4 years, during which time she attended 4 different private schools. She was out of school for several months when they moved from Slough to Barking, and a school place wasn't available to her. And I think actually because she didn't have advocacy, there probably would have been a school place, but they couldn't get it because the mum didn't know how to navigate the process. Her family's situation actually ended up in court when their refugee status was granted, because Redbridge Council housed them in a total of 11 different hotels in 4 months. At this point, she'd just started in year 7 at a secondary school. And although their legal case was related to failures in mainstream housing, I wanted to highlight something that the barrister from Redbridge Council said, which I think demonstrates an attitude that Home Office policymakers can also display. He said that because this child had moved schools so many times, she'd be able to move schools more easily because she was used to it. I'm glad to say that the judge picked up on this and countered that because she had been moved several times, she was more in need of stability in her schooling. However, this attitude of normalising and even justifying abusive practice is becoming more and more prevalent. This is how she describes her experience. Before I started at Valentine's High School, I went to lots of different primary schools because we were moved around so many times because we were asylum seekers. I went to 4 different primary schools after I arrived in the UK. When we first arrived, I went to Penwood Primary School in Slough, which I don't really remember. Then I went to St Anthony's Primary School, which is the other side of Slough. I liked that school. I had lots of friends there and I didn't want to leave, but I couldn't stay because we were moved to London, so I had to go. I felt very sad when I had to leave. I felt like all my childhood friends were there. When we moved, I felt sad for a long time. Half term, we tried to go back so I could see my friends. I felt devastated. When I left St Anthony's, we were moved to Barking in London. I couldn't get a school place, so I missed several months of school. My mum helped me to learn at home, but I felt alone and I had no friends to talk to or teachers to help me. We only had 2 rooms to live in, and that was for her, her mum, and her 2 little brothers. Then I got a place at Latham Junior School in Barking. I felt shy when I arrived because it was a long time since I had been in school. I didn't know how to make friends for a few months, but then I started getting closer to people and my studies got better. The teachers at Latham were really good and helped me catch up, and then I started getting achievement points. I had to make new friends again, but in the end, I was only there from year 3 to the end of year 4, and then we were moved again to Haringey, and I was moved to Willows Primary School. I liked the Willows, but while we were there, we had all the housing problems and we were in lots of different hotels and had to travel the really long journeys to get to school. I had to get extra help at school because I was so tired and we were being moved all the time. Mum did keep us at school, but it was difficult and we were often late because of all the buses and trains. I started to zone out in classes and I couldn't concentrate properly. I had to have a social worker to help me. I've just started in year 7. I think it would be much harder to make friends now. It's much harder in secondary than in primary because everyone's already in groups and have their friends already, sometimes from primary school, so it's harder to get into the groups. Other kids might have relatives in schools to help them make friends, but I don't have that. I don't know anyone when I started because I didn't go to a nearby primary school. I feel great about my school now. I felt I had a place to settle in. It's like a new beginning for me at a different stage of my life. I have good friends at school, they help me and I learn from them. I want to stay at my school. I don't want the same thing to happen like at primary school where I had to change all the time. I want to finish my GCSEs here. I'm into building and I want to be an engineer, but I also love playing football. I don't want to move schools anymore. I want to stay with my friends so I can feel that I can belong. I'm glad to say that this family won their case, thank you, Osborne's, and this child was able to move back to Redbridge and stay in her school where she's now doing extremely well. I'm going to close with a heartfelt request that is quoted in the report to the Home Office from a parent supported by Caras who provided a case study. I sincerely request that you revise your policy and practices around school admissions for asylum seekers. Extra support must be given to ensure that access to schooling is a priority and that all children and adolescents are treated equally regardless of what country they come from or their immigration status.
Obviously, thank you very much, Lucy, and thank you for the child you shared who's prepared to share their experience with us, which obviously brings home the reality of why this report was necessary and hopefully why this report can lead to action to raise the profile of this issue and potentially assist if there are legal challenges, but also to encourage individuals who are experiencing these kind of problems to try to get support and access some remedies where they may exist through representations or through legal advice, recognizing that we do face a fundamental problem with lack of access to legal aid, and people qualified who take on education cases. Education legal aid was taken out of scope in 2012, and there has been a gradual decline, so that it's one of those areas, as in many other areas, where there's a fundamental shortage and lack of people who are dealing with this kind of issue. Obviously, it covers a number of aspects, not just education, even though that's the focus of it. If you're doing accommodation cases, then obviously this report will be of assistance in giving you a focus for saying why this problem is known to the Home Office and needs to be addressed. They can't just simply say, well, you will have a place, because now there's a report that's saying that isn't the case. So that's why obviously this piece of research is particularly important. I did wonder whether you were able to capture in the information the number of times that children were moved, or was that the kind of detail that was too granular to collect because you went to organisations?
I think the focus was on delay.
It was on the delay more than anything else, because obviously
The really important thing though was that in that we found out that just a fraction of organisations actually collect any data on kind of education delays anyway, so it's kind of a big unknown.
yeah, so that obviously is, if there's multiple delays for children, then obviously that's going to have a cumulative effect, which your final contribution really brought to life, just what that must be like for children and young people who are moved around and face these sorts of disruption. The saying is disruptive really doesn't begin to explain what the emotional and the practical consequences that there are. So obviously that may be the other thing, that there's a need for further research to look at those sorts of detail of numbers of times that you're not able to access education. This overall statistics are there are about 20,000 children who are in asylum accommodation. So obviously research projects such as this is going to be challenging to get the sorts of data. And obviously one of the legal routes that we have when you have a situation like this is to say to the Home Office, well, what does your public sector equality duty tell you about your practices? And because increasingly the courts have emphasised a duty to monitor, then it may be that that's going to be one ground, a useful ground of challenge, because that's obviously an issue here, isn't it? You can't assess the equality impact on young people of the policies on asylum accommodation and their education if you don't know the true information about it. So it may be that that's one important route that we should be starting to consider in terms of systems challenges, is that we know anecdotally, and this report now is seeking to bring together and to demonstrate that there is a problem here. You can't possibly reflect the full nature of the problem. It's the response, but once you've raised it with the relevant public authority, they should have been doing it. They should have access to the information, because as we've heard from Matthew, there is a duty to provide suitable accommodation to every child, irrespective of their immigration status. So you would want to know, if that's not happening and there are delays, what's the volume of the delay, what's the gravity of the problem? Because unless you've got that granular detail through monitoring, you can't begin to discharge your duty to assess the impact. So I think that's one line of challenge that might be will be an important one in terms of having a true picture of the impacts, of which your report is obviously, this report is a very powerful snapshot, but it can only ever be that, because how can you get access to know what's happening with the 20,000 children? We can extrapolate that it's likely to be a similar picture in most places. So I think that information is obviously an important part. This report gives the foundation for saying more information is required. I think the other thing that seemed to me to be important from what you'd said was that there is good practice your explanation, Nick, of your local authority was inspiring, if that's what they were prepared to do. And if they were able to do it, then why can't others? So we want to also to be able to present not just the negative picture, which has to be out there, but also, well, actually with an authority that's properly discharging their duties and making that a real live experience, we will make the provision for these groups of children, and it can be done. And I think that it's important for somehow to collect that information, to put that, to get that out there too. So those are my kind of immediate responses from what you've said, and I obviously want to open up the floor. We've got a question online, if you're happy for me to take that one first. So the first question that we have, which is from, I think it's from Rebecca of South London Refugee Association. Thank you for your question, Rebecca. She asks, are there any examples of or opportunities for schools to challenge the Home Office's dispersal policy for children in school? So that's looking at not from the perspective of the local authority, but from the school.
A school would, I don't see why a school would be the best placed challenger in that type of challenge, because I guess there's two elements to that. There's local authority in schools, and then there are academies. And academies are outside of local authority control. And the way that dispersal decisions work, I can't see that it would necessarily always require an academy to admit, because there'll be a range of school options within that local authority area. And so it's unlikely that a particular school would be obligated to take a large number of places. Fair access protocols primarily put the responsibility, and the Section 19 duty primarily puts responsibility on local authorities. So I can't see why a particular school, unless they're being compelled by the local authority to take a large number of pupils, and then that challenge would not be to the Home Office, it would be to the local authority, I would have thought. It's an interesting idea, but obviously schools can provide valuable evidence about the pressures that are being placed upon them, and also the need for additional support for children moving into the area at short notice. But I think school as claimant to judicial review would not be the obvious way.
Yeah, well, I think it raises the point that was mentioned by Matthew about the case that was brought by Brighton and Hove City Council, which was that they had two hotels in their area where unaccompanied children were being accommodated outside of the lawful provision of accommodation for children under the Children Act, which the court ruled was unlawful. But what Brighton's approach was to say, well, we are a city of sanctuary. We want to be able to provide support to children, but it needs to be done in a lawful way, and you also need to properly resource it. So they weren't just acquiescing, as many local authorities do, in the fact that they have, as has been explained, large numbers of people can be overnight be put into their area because they're dispersed and they simply don't have the capacity to properly deal with it, or in order to do so they need some more resources. And I think that if there is any thing that we would want is, local authorities or schools can be the focus of individual challenges, because that's who you focus on. They're the one who's not providing you with what you're legally entitled to, but they've sometimes been put in impossible positions by the Home Office policy. And I think there is a lot to be said for working more constructively with local authorities, for them to say, well, look, you've got these duties that you're going to breach if they don't properly liaise with you, if they don't properly resource you. Why are you facilitating or acquiescing in that? And maybe representations through the local government association about these issues to follow up on this report, rather than just leaving it to legal challenge. We're saying to them, look, this is a problem. It's a problem for the children that are in your local areas. You have the legal duty to make the provision. The system is not operating effectively and is failing in many respects, with harm to children. So what do you want to do about it? Don't sit there and wait for a legal challenge against you, because then that's resources of the local authority that are scarce being spent on defending position to whatever extent they do. Or the lottery of if you've got a lawyer, then maybe they're going to acquiesce. But for all the people who don't have access to lawyers, they remain in difficult positions. So I think there's scope in this context to be saying to local authorities, we understand that this is a challenge for you because you have a lack of resources, but it's not, you can do something about it. Brighton is one example, but whether or not, I think it was easier for Brighton. They were a newly elected Labour council when there was a Tory government, and there was an opposition to the use of hotels. It was politically expedient. I don't think that's what happened in Brighton, but it kind of worked. Now, obviously, it may be that you're going to have to go to Tory councils because they would be having to say they're criticising the Labour government. And all those political issues come into force. But the ultimate bottom line is local authorities don't just have to pick up the pieces of what are often both incompetent and cruel Home Office policies. So I think that this is a message that we would want to potentially have them as an audience rather than just ourselves. We're always talking to ourselves, aren't we, about how bad everything is, and we know it is, and we agree. But maybe we have to look at local authorities as potential, at least potential source of support and have an interest, their own interest, as well as properly complying with their duties and the interests of the children. If they wanted to put them first too, then that would coincide. I think that's and schools may be in a similar position. We'd like to take more children, we'd like to take this child, but if it's multiple children who have special educational needs, even if it's only language ones, we need some resources to do it, instead of shutting the door and not taking children into the school where they could. So we've got no other questions online. If anyone else wants to make a contribution, that would be great. So if you want to just say who you are, because I can't see me.
Yes, hi, I'm Karen. I work at the Indo-American Refugee and Migrant Organization. So we're very similar to you. I believe you might have filled out the survey. I'm not certain, but we're based in Brixton and we support Latin American migrants and refugees in London, but also across. And it really resonates, everything that you're saying, the experiences that are mentioned in the report. I can say that is absolutely our experience as well. I have a different perspective when it comes to engaging with local authorities, and unfortunately, it's not very positive.
Yeah, sure.
But again, it may be a very unique situation to South London. Oh no, okay, then it's.
That's my one positive experience.
No, I haven't. Well, I guess something that came to mind was this idea of local authorities that are acting also beyond their legal authority. So I feel there is a cultural issue in local authorities acting a bit as runaways. And in my experience, I also do a lot of casework. I have seen local authorities tell me, as a blanket policy, they do not trigger for access protocols for year 10 or year 11. They just don't do it. That's what they do. So they eliminate the only accountability mechanism that they have. I have a local authority who asks for boarding passes for families to be able to sign their children up for school. When asked, you can't do that, they say, of course we can, like, it's gonna stop us, when we ask them why they were doing that, their answer is, well, we need to know that the child is in the country in order to be able to prioritize them, but still that, we tell them that's not the way to do that. And again, we know that asking families for a boarding pass and other documentation that shouldn't be asked for is really problematic, and they do it. And then also I feel like with schools specifically, you have academies that are not transparent about the reasons why they're not taking year 10 and year 11 students. But in some cases we have called schools asking, like, do you take students year 10, year 11? And they say, no, we don't take any year 10, year 11 students, especially not in year, because it's complicated, it's tricky. We don't have any AL coordinator. So how are we going to welcome these students? So there seems to be a huge systemic issue as well. And really bad practice within local authorities, pretty unfriendly within the local authorities who are not really always super keen to help. Again, I know this is quite different in areas that have a high concentration of asylum seekers, and we understand that. But there also feels like we've seen a real difference when we have advocates in schools. We have a teacher, for example, she's Colombian, and she has a real kind of connection to the head teacher, and that school takes, I want to say, 50% of the children that come to IRMO, they go to that school, and she's an angel and she does that advocacy. But it shouldn't be up to an EAL coordinator and advocate to be making those decisions. And so we see that whenever families can apply directly to the school, that works well. The school engages in best practice. They have admissions forms that are in multiple languages. They make the process easier. But what we've seen is instead local authorities that have immigration status questions on their in-year application forms, forcing families to report this when that is not one of the admissions criteria they should be asking for. So it almost feels from the perspective of organization, like where do you start tackling this issue? It feels like the law is sort of on our side because we know that there's a duty to provide this education. But the local authorities are acting as they want, and sometimes it's in bars of sanctuary. And that just feels.
Yeah, I don't know if anyone else wants to contribute their experiences if before we kind of respond on that, but is that what other people have experienced from different local authorities? Is that common? You want to just
Bethany from practice. I was just going to say a little bit about thinking about local authorities challenging, and I work with a couple of different local authorities who tried to do some stuff around the asylum hotels in the area. Newham, the borough that I do a particular amount with, who really tried to get. They've had education workers go out into the hotels and try and find where the children are so they can get them into schools and things like that, help people to apply for zip cards and all that kind of stuff. So they have been trying. But one of the interesting things that they were looking at when the whole Baby Stockholm stuff was around the barges, they were looking at putting a barge in London docks, the government, and Newham were gathering information about the cost of having asylum seekers on their local services to try and fight against the government putting that barge there. So just thinking about that from the perspective of some kind of challenge and looking at the costs to local authorities, as you say, it puts them in a very difficult position. And that there might be a local authority willing to do that kind of action, I think, potentially in terms of that challenge.
Yeah, I think there are other authorities that were considering that because the other angle, the other situation which you've touched upon is even when the person is recognised, their family are recognised as refugees, then it immediately becomes another problem because they're going to lose their asylum support. That was being done by the last government en masse. So that was a situation where local authorities suddenly had the duty to accommodate. And that was a major issue for them. And there was some discussion about Waltham Forest, I think, considering whether they would challenge it. So there wasn't in the end. So I think that there's, it's not all this, it's a complex picture. And I imagine that what the first contribution, sorry, I've forgotten your name, Karen said is probably the more likely experience that you have. And certainly, I don't know if anyone else wants to contribute about that, but I mean, what you're describing about asking for immigration status documents, there was a challenge to that practice that they backed down on, the Department of Education backed down. They cannot ask that. It is unlawful, it's discriminatory. And so you can, that can be disputed in the way that you've said. And maybe that's the other thing about collecting information about a local authority and then bringing a challenge. My suggestion wasn't, challenges are important. But if there is a good practice that we can bring forward that other local authorities are doing, that you're describing, Newham, and say to local authorities, well, come on, you need to discharge these duties. And if you can't do it, then you need to be saying something to central government, not just adopting these unlawful practices. And ultimately, that's what the situation was in Kent, because they had large numbers. They just decided to say, we can't take any more children. In that case, which I was involved in for Brighton and Hope City Council, the judge asked Kent, well, how many children who are British have you said, or settled community, have you said, we will not accommodate you? And of course, there were none. Because, so the crisis wasn't a crisis overall. It was that they were treating asylum-seeking children as the crisis, but it didn't there was not a single ever child who wasn't asylum-seeking where they've gone, we haven't got a space for you. They always could find it. So would you like to make an observation about?
I think the issues around schools is getting enough children in one school at the same time. So I think hotels sometimes open and happens in terms of one school accepting quite a lot of children is that it's the school that is unpopular. So that's the school that will have places and that's where the children end up. But also the level of mobility is such that I'm thinking of several different hotels and schools that the children went into from those hotels. They didn't stay there, generally speaking. So by the time you've got together something that you could put together a challenge, that lots of those children would have been moved on to other places and other schools. So I think it's quite difficult to do that. And I agree totally with what you said about good practice and that thing of it being a lottery. You get one fantastic teacher who does a load of advocacy in the school and brilliant, and then you get another school and actually they're not that keen, and even getting 3 school meals for children becomes a huge battle, even though they have eligibility. And you know that in that school, particular schools that I've worked with, they've been not keen to do that, and partly because they know that child isn't going to stay, so they don't want to invest all their scarce resources in a group of children who are going to come in, require a lot of support and help, and then, you know, maybe a few months, maybe even a few weeks down the line, be moved on again. So it's very difficult, I think, for schools, and also the level of instability that it makes in a classroom for teachers, having children coming in and going out is very difficult. So I don't know how you would manage that. It's quite difficult, I think, to look at it from the school's perspective. I don't know, Nick, if you had any.
I'm going to feel sorry for a council for a second. Bear with me. This is the second time it's going to happen in my life. Going back to that really good example of practice I was talking about earlier, that local authority were given less than 24 hours notice that that hotel was even opening in a small rural town in Oxfordshire that has maybe 2 secondary schools, both of which are nearly full, and a couple of local primary schools. But because of its rural place, if you can't get into those ones, it's 4 hours and a horse to get to your nearest other primary school, which if you don't drive and live on £8 a week is really hard to be able to do. And I also don't understand how that could even be reasonable to expect a local authority to conjure up health services, educational services, support services, youth groups, all those things that children need in less than 24 hours. They literally told the local authority as they were putting people in taxis to send them to the hotel they just decided they were going to open with no consultation at all. But there is, with will, it can be done. My example, they can be done, and it can, but then local authorities are also, how many are going bankrupt in the next few years or have served those rule notices? Isn't it like a third of councils within the next few years are going to have nothing but their essential services? Something has to give somewhere down the line in kind of a climate of austerity, service cuts and everything else that is wider than this issue. And relates to kind of more systemic disregard for children's rights, if I can be so daring. And it needs looking kind of root and branch as to how we approach it.
Can I ask a question about the move-on period and the sort of transition from asylum accommodation to local authority? Because obviously there's the move out of NAS accommodation into local authority housing. I assume, I haven't really thought about this much before, there's also a transition from Home Office subsistence related to home to school transport provision and going into the local authority's home to school transport application process, which takes a whole lot longer than 56 days generally to resolve. And if you're moving place within the borough, or even being moved out of borough by the relevant local authority, there's probably going to be some gap in the provision of sort of Home Office paying for your transport and then getting into the local authority's home to school transport scheme. And I'm not that familiar with any local authority having a special arrangement for that cohort that need home to school transport provision. And it's obviously a huge issue if you've got a child moving like an hour away from their current school mid-year because they've been granted refugee status partway through maybe even their GCSE year. That seems to me to be a lacuna, and I just wondered what you see in practice.
What Home Office support for school transport?
That's what I was gonna
My first question.
Sometimes you need to get some form of funding.
You make a long-winded, low chance of success
Yeah.
discretionary
Exactly.
application for additional assigned support funds,
Yeah.
maybe.
Yeah,
So even that's not actually being provided.
Yeah.
You've been successful once, maybe twice.
yeah.
Once.
Okay.
Okay, so there's no transition problem. There's just a lack of.
Just a problem, but it is a transition problem because it's the same thing. You know, you look at kind of transport costs quite often, more than not when local authorities, decent ones, do organise, it tends to be quite local, quite easy. You know, everyone, loads of people in this room, plug the gaps, bikes for kids through the refugee bike project and all of these sort of things to enable all that access, and then you'll move to Durham.
Yeah.
And it's like, here is your new school, here is your new thing. You can't take your bike because you can't get it on the train, and the local authority or whoever's moving you will not pay for a van to take your stuff to Durham. You're on your own, so you're back to square one again, and kind of off we go. And you know, it doesn't really touch the sides, does it? The only saving grace is that a lot of councils, boroughs, etc., free bus passes, different kind of schemes to mean that children travel for free. Zip cards for the London-based kids, and Oxford runs a free scheme for bus passes and stuff, which quickly get whipped away the second you've got status, generally, apart from zip cards in London. But then quite a lot of those children are out, right, and moved away from London.
Yeah, I'd say one other thing about that, which is that the answer that local authorities and the Home Office often give is just move your child to a different school. So when they get moved on, the parent often and the child wants to stay in the school even though they're further away, but they won't pay them if there's a possibility that the child can be moved to a more local school. So the first answer is move your child. And unless your child is doing GCSEs or public exams, you don't really have I don't think there's a lawful argument about that.
But also on that, that's also 186,000 non-refugee children who are just in temporary accommodation for 15 years because there's a lack of social housing. And this is a general problem as well with how education is viewed in the context of their importance in a child's life.
I think that's a really important point, that this is obviously not just the experience of asylum-seeking children. The figures for children in temporary accommodation, including hotels, pending applications, provision of homelessness accommodation, is through the roof.
Yeah, and actually that's the child who gave that testimony, as you heard, the situation for her got a lot worse when they got their refugee status. That was when it really got appalling.
Yeah, that's obviously a shocking situation. You think that getting the status is going to be moving forward, but it's a beginning of a whole load of other problems to rise. And I suppose in that sense, that's an important point to make, isn't it? Is that we are focusing on a particular category of children who are going to have additional issues because of the trauma, because of their asylum seeking. So that creates a whole load of additional issues that other children do not have, but they do have a lot in common in fundamental ways in terms of the way in which the system is failing them. And it would be important to make sure that they're not divided, and that the common issues are promoted and awareness is raised about it, because obviously what we also have to be conscious of now, and which both central government, local government has to be addressing when they do have these kind of policies, is what is the impact of creating a situation where you would place lots of children or significant number of children in a failing school, or a poorer school in a poorer area that's already struggling and they don't have the resources. What's the community relations implications of that? And that doesn't mean to say that you shouldn't do that. That means you have to put the resources in so that the community is going to accept children and is going to welcome them, which is what you want, and it isn't going to create hostility and an environment that is not just deliberately hostile created by the government, but then also in the current climate in some contexts where you have to deal with actual hostility from the communities who are also suffering from lack of services and deprivation. That's a major issue, isn't it? And none of this helps, none of it. The word that you used about integration is a critical element which should be integral to any policy about asylum seeking families and children and people who come here, because that's how you address the underlying situation that we have deliberately created by the last government, particularly the last government, not exclusively the last government, whipped up by the media, of anti-asylum seeking xenophobia. And that, having children in an environment like that is obviously so damaging to them, but it's also the route through by which you challenge these horrendous stereotypes that have been created, because a kid is a kid, and they're gonna, if asylum seeking children in your school, you're gonna get to know their parents, and it's gonna break down the negative stereotyping that's so dominant and disruptive and damaging. So obviously there is a big picture here, and schools can play a key role in facilitating integration and a sense of welcome, and challenging the common narrative that is so damaging to asylum seekers and our society as a whole. So it obviously plays an important part in the big picture. Is there any other contributions that we have from in the room? And there's nothing online.
Someone has shared the Mayor of London Asylum Welcome Toolkit and has
there we go.
suggested, is it possible to work with or get a section on best practice about education? And then they put, sorry, this is London focused.
It might take about 3 years to get it in there, but it's possible.
So the implication of that is there's nothing that in the toolkit, it doesn't even address education. Is that whether the implication is?
yeah.
Okay, well, that's obviously tells you quite a lot, doesn't it? It may be that's, again, the report can be the foundation for making some representations, because you would hope at least that Sadiq Khan would make this a priority issue, an important issue, that he would take it on. So I think that's something, an action step could be taken in terms of what engagement there could be with local authorities. And we've seen, just to sum up on that, we've seen that there's good practice to promote. There's where there is a willingness to try to do something different, then we want to be able to use research like this to say it's imperative that you do. Obviously, in circumstances where you've got local authorities that are following a exclusionary, hostile agenda, then it may be that your only remedy is litigation. But at the same time, if you're able to show, look, this can work, and you can also seek more resources, then that might be a strategy that we done, and maybe approaching the local government association to emphasise it is something that can be done. And then ultimately, there obviously will be many potential individual challenges that can be brought for children who are having such a damaging and destructive experience. Because, as we said at the outset, this is not a right that is in any way connected to or dependent upon your immigration status. Each and every child is entitled to suitable education. That's what Parliament has decided. We're often dealing with cases where Parliament has decided that asylum seekers and refugees and other migrants must be treated in a negative way, and there's a legitimate reason for distinguishing and treating them differently and adversely. Children is not that situation, not at the moment. And hopefully with this government, we wouldn't be going back to a situation where any group, however vulnerable, are not off the table for protection, which is where we got to last time with the last government. Children are children first, and their immigration status doesn't make a difference. And that's what we need to be emphasising. That's the message, isn't it, that needs to go forward. And that's clearly not the case. They do have a differential adverse experience of access to education. That discrimination is unlawful and should be challenged in whatever forums we are able to pursue it, whether it's the courts or in representations or government policy or local authority policy. And obviously individuals are making a difference when they get involved. And that's the message that comes from what you've described. Where you are engaging, there can be an alternative way of promoting integration and solidarity with people who need support. So on that note, I think that we can probably wrap it up there, and I'd say thank you very much for all of our speakers who've shared this important report from a number of different angles, and I hope it will be of assistance in whatever work that you take forward from today. And as I said, we